This this is a program on drafting of agreements and the basics of the contract principles that you will apply in your legal practice. So I want to today do this video to explain actually that how does the drafting happen in practice. This is different than learning the law of contract in the university. So I want to cover a number of points that will explain actually that you understand the basic principles of contract law: offer, acceptance, and then the consideration is the principles of law that you understand at the university when you learning the law of contract. And then when you apply that in practice, it's a very different scenario actually. So I just want to give you an example that once you have the principles of contract in the evolution of the law of contract from England and then in Ontario, then how the law has evolved. So historically, the original principles of contract were applied in specialized areas of law, such as drafting a lease. And the lease became very complicated and became evolved as a contract that applies specifically to land and property. In the case of the mortgage, it applies to the borrowing arrangement that is also an agreement of lending that attaches to the property as a mortgage. So these are specialized areas of law. But when you're drafting a basic agreement, then what do you have to think about? So I'm going to address the remark, and firstly, this is a video that is being prepared for the Angel Mentorship Group, but it's open. This group is open to anybody, and once uploaded in the social media under Angel Mentorship Group, anybody can watch it. And I hope you will join the group and watch some of these videos, which are aimed at helping lawyers and paralegals to launch their practice and understand how to use the basic principles of law in practice. So today's topic, I want to take an example of an agreement that I was preparing for the purpose of two persons who will be coming together and say, let's invest in this property and buy a condominium, and one person will be staying in the condominium, another person will invest equally, so they're two partners, but one will be a tenant. So when you're drafting this agreement, there are two areas of law that intersect. One of them is the principles of contract. Second is the principles of a partnership arrangement, and the principles of real property also intersect to understand how should you use these different areas of law to create one agreement. So I think what happens is that when you study this area separately and you put these thoughts together, then the tendency is to try to use the elements of the existing types of contracts and create a precedent out of it. It's very important that you don't take any precedent and just use it mechanically, but you should think out the arrangement. So let's take this example of what would you have to think out when you create an arrangement which is rental in nature, contract in nature, and it affects the title of the property. So should you, for example, ask the client to own the property as tenants, joint tenants, or as tenants in common? So I think this, in the theory of the law, be very clear actually that if you want the right of survivorship, you would make it as joint tenants so that the owner who is left behind as a survivor will continue to own the property. So you wouldn't do it with a stranger, you would do it with a family member. So when the client comes to you, you figure out the relationship between the two parties who want to invest in the property and check out that they're related or unrelated. So then you make the decision. So in my case, I decided that it's tenancy in common, where you can basically own your separate share of the property. So once you make the decision that it is not a family member, the second question will arise. One person lives in the property and the second is only investing. So who should pay, so to speak, the mortgage, and who should pay the rent? So the rental arrangement as a landlord and tenant will apply. So should you make it a residential tenancy agreement, with all the clauses that apply, and if some dispute arose, you will take it to the tribunal as landlord and tenant situation. So you have to combine the elements of their thinking to create an agreement where only one person is the tenant. So I think in my case, I made the decision that they're partners and one is a tenant. So you pay the rent every month through the person who resides in the property, and the person also is an owner of the property. So the question then is, do you pay half the rent or the full rent? If you pay the full rent, then you should reconcile the accounts at the end of the year, and then say in the agreement that at the end of the year, you will take account of all the revenue through the tenancy arrangement and the expenses, and then when you have the two reconciled, is there a profit, is there a loss, and who is going to share in the loss and how. If there's a loss, the two will share the loss. If there's a profit, the two will share the profit. So the rental arrangement should take into account that you'll cover the basics of the expenses, like a typical landlord would, and that would include the common expenses, repair expenses of the household, and you have to consider the electricity bills, utility bills, etc. So these are the expenses that you have to take into account and mention them, so there is no misunderstanding between the two parties in their minds what the intention is in the relationship that you're creating for the client in this kind of a situation. Then you prepare a draft agreement taking all these things into account, and then the client should review this agreement and then say, yes, I read the agreement. You have then advised the client, and one of the things that happens is that in agreements very often you prepare a solution of the problem that has future implications. So we're not going to, as lawyers or paralegals who will be drafting this kind of an agreement, be looking at the future of the relationship and predict how they will get along with each other. So you have to create a solution in terms of what happens if one person fails to make their payment, especially the tenant. The tenant, for example, misses out two payments, and there can be a lien on the property, and doesn't tell the other person that there is a lien, or they're traveling and they're not in town to even know that they're in default of the payment, and the other person gets to know. So there should be a method of communicating between the two persons, which you would write down in the agreement. Where will the notice to the person be sent? So if the other person not residing there helps the person who is in default of making the mortgage payment and the rent payment, and the other person has to subsidize the payment obligation, which are incurring from the mortgage, the monthly expenses, and so on, then there should be a clause to say that that person would be reimbursed. But when and how? So if the one person is in default and doesn't have the money for whatever reason, they fall sick, they can't have a job or something, what would you do? So in my case, I had to create a solution of the problem. Well, if you sell the property, you would first reimburse the person who was giving the money in addition to the half interest in the down payment and the monthly expenses as an investor. That person is now coming forward to make additional payment beyond the half share as an owner of the property, and therefore the clause would say that you are now going to be reimbursed when the property is sold. First to the person who gave more than half their share, to reimburse the the mortgagee and other people who claim against the property. And then once you pay that amount, then the parties assume their equal relationship in the event of a sale of the property. So you created a solution to the problem which you have to think out, which in the way we understand the principles of law in the university, there is a need to create a problem-solving mindset, and this is an example of where we have to create the mindset of problem-solving and trying to figure out all the different possibilities. And then for the lawyers in practice, it is very important that you take precautions that you're not found to be negligent in your practice. So you should have an acknowledgement from the client that they've understood the agreement. You would send the other person to another lawyer, because there's a conflict issue. In the common law, we solve every problem through the ILA principle. That means the lawyer is acting for only one party at a time. So when you take in these precautions of acknowledgement and saying, I understand the agreement to your client, and send the other person to the ILA, then you have more or less looked after what can go wrong. Because one thing to remember in negligence for the lawyers and paralegals is the negligence, if I can put it in my words, is in the eyes of the beholder. If the client thinks you're negligent, he has a right to bring an action. The insurance of the lawyer gets into picture and it gets messy. So try to create a record in every file that you do to have the precautionary measures to make sure that you are not ever considered in the eyes of the client negligent. So the attitude of caution can make a big difference in the arrangement. So if you need to get a witness to, if there's somebody in your office to watch the signature as a witness, then I encourage you to have the agreement witnessed by another person in the office, at which time you recite the understanding, did you understand the agreement, and then you let the client have it. And that would be the way I would suggest that you do a contract. I hope that was of interest. If you enjoyed the video, please make your comment below. And if there are topics that you'd like me to cover for you in your practice, then let me know also on the social media under Angel Mentorship Group. And if you would like to join the group also, you can ask for the invitation and we'll let you join the group. And this group is an open group, and any lawyer in any part of the world, although it is an Ontario-based issue that I'm discussing, that anybody can join and understand the legal principles, because more and more people want to understand the law rather than just telling them to solve their problem. And so it would be helpful to people who are also not lawyers. Hope you enjoyed it, and see you again. Bye.